May it please the court, my name is Jonathan Harwell. I'm here on behalf of the appellant William Watson. If I could reserve 5 minutes of my time for rebuttal. I would propose, with the court's permission, to address maybe the issues in the reverse way that you might have been expecting. I'd like to talk first a little bit about the facts and the error that we are claiming occurred, and then secondly to talk about the claim that we don't have a right to appeal.
Could we talk about jurisdiction first, please?
I will. I'll go that way if your Honor prefers.
No, that's okay, because the jurisdictional issue is an interesting one to me. Is there anything in the language, in the text of either the resentencing statutes or Rule 3 that grants an appeal as of right? Is there anything in the language?
I think there is nothing in the language of the revised drug-free zone statute 3917-432. It is our position that for a defendant such as Mr. Watson, there is language in Rule 3 itself.
We're not appealing from the original judgment. We're appealing from a new judgment, as I understand the argument?
Yes.
Okay. What's the language that allows that?
Rule 3 says appeal as of right lies from any judgment of conviction entered by a trial court on a plea of guilty, and then skipping down, if the issues presented for review were not waived as a matter of law by the plea.
That's in the context of a guilty plea, though, right? A Rule 37 plea?
That's certainly when it most often applies.
In fact, that'd be the only time that it applies, right?
I think it applies here.
Okay.
I mean, it doesn't say original versus amended judgment. It just says a judgment of conviction. We have that here. It says any time there's a plea of not guilty, you can have that. We're not under the plea of not guilty. But it says if there was a plea of guilty, you can have an appeal of issues presented for review that were not waived as a matter of law by the plea of guilty. Here, these issues came up after the plea of guilty, so they certainly were not waived by as a matter of law. So I think that differentiates Mr. Watson from the prior cases that this court has addressed, where there was a denial, and therefore there was no judgment that there was still an appeal available from. You can't appeal from a judgment years ago. But here, Mr. Watson has a judgment that was entered in 2022. He filed a notice of appeal under Rule 3 within 30 days of that judgment. It is an issue that he has never waived. He objected to, indicated he was going to appeal from. And so can I say that when the drafters of Rule 3 had this in mind, when drafted it, they had this in mind? No. This didn't exist at that time.
That's kind of the issue, right? Because we would interpret statutory text, including the rules of appellate procedure, in accordance with the ordinary meaning that people would have understood at the time of the enactment. And it looks to me like that language in Rule 3, not to say that you might not have other remedies, but in Rule 3 particularly, it looks like that language is referring to a certified question guilty plea procedure in Rule 37, because it's referencing Rule 37 in that same part of the sentence. That's not your view?
I disagree. I think that the subsection or sub-sentence that we're relying on is actually a catch-all provision saying there's probably some things out there we hadn't thought of, but if there are other issues that weren't waived and are apparent from the record, you can appeal those.
Okay.
A different part of Rule 3B specifically talks about certified questions. So this, if the issues presented for review that were not waived as a matter of law, that's not talking about certified questions because earlier in that same sentence, it specifically talks about certified questions under Rule 37.
Okay.
Mr. Harwell, I want to ask you about a statute and how it comes into play on this jurisdictional question. 4035-401A says the defendant in a criminal case may appeal from the length, range, or the manner of service imposed by the sentencing court. How does that affect your jurisdictional argument here? Is it an independent basis of Rule 3? I guess is a more precise way of asking it.
I like that. I mean, that is what we are appealing from. We have a sentence that does not comply with the statutory structures for length and range classifications.
Doesn't it create an awkward jurisdictional situation, though, where you have a case like Bobo and the handful of other cases that we've discussed, where the defendant's motion was denied outright, no relief was given, and there's no right to appeal as to that. But you're arguing where a defendant has been granted resentencing, has been granted at least some relief, they would have a right to an appeal there, and not in the former situation. Does that not create an awkward jurisdictional case?
I agree. I think it was to the extent that a right of appeal was not provided from defendants who were wrongly denied a resentencing. That seems to be a legislative oversight, or maybe there is some statutory provision that I'm not aware of that would provide that. There is, the fallback that we have as well of the common law writ of certiorari. But I guess one policy differentiation is that unlike the defendant in Bobo or some of the other defendants, Mr. Watson has a new judgment. And you can look at that judgment and read it and know, actually, this doesn't follow, this isn't a legally correct judgment. We have an offense, we have a sentence, and there's no statute that would justify that sentence being correct. Certainly, if I were making the law, I would provide a right of appeal for the defendant in Bobo and other cases, but I think legally that's a different question, and we have a much easier argument for Mr. Watson. So I think the straightforward argument is the Rule 3 argument. As I said, that language, issues presented for review were not waived as a matter of law. I think that reads as a catch-all for what other situations that may arise, the only limitation being there has to be a judgment. So that's been the problem. I know there's a line of cases about appeal from a trial that resulted in judicial diversion. You can't appeal from that because there's no judgment of conviction. But here, Mr. Watson has a judgment entered that he timely appealed from. That judgment sets out on its face a sentence that does not comport with requirements for how you can determine a sentence. And the other option that I don't think we have to go to would be the common law writ of certiorari, which applies when there is no right of appeal, but there is a fundamentally illegal ruling or a ruling that is a palpable abuse of discretion. I think both of those, if this court were to find that Rule 3 does not apply, or the 4035 statute that Judge Hickson mentioned does not apply, then the common law writ would certainly apply under either the palpable abuse of discretion or the fundamentally illegal ruling standard.
The state also suggests that you would have the right to petition under 36.1. What were your thoughts with that?
I don't know is the answer, and that may be correct.
The fallback, I think, with the state, I don't know what they'll argue, but my guess is they would argue that the sentence would remain the same because it's to the benefit of the defendant under Rule 36.1. I was wondering if you thought that Rule 36.1 would actually provide an avenue of relief in your situation, even if it were illegal.
I don't think it does because we don't have to get there. The problem arises out of the line of cases dealing with hybrid sentences. So in certain circumstances, obviously, there can be a mixing and matching of sentence length and release eligibility calculations. And the courts, as I understand that, cases approving that, have basically said that is technically erroneous, but it is something that the parties are allowed to negotiate.
I think it's a little different than that, right? I mean, those cases typically arise out of a plea agreement. Hicks, for example, arises out of a plea agreement. It's a different situation if the trial court on its own authority starts mixing and matching range, release eligibility, things like that. While it might not be an illegal sentence because the sentence may be authorized by some statute somewhere, it is an appealable error. And so it could be corrected on direct appeal.
Yes, I think that's what I'm saying. Because it is, I guess I am not absolutely sure whether it would qualify as a illegal/void sentence because it is an impermissible sentence and there's no indication that it was done by means of a plea agreement, or whether it's just an erroneous sentence subject to appeal. And so I'm not really taking a position on whether 36.1 would be appropriate because I think it is just, at the very least, it's an appealable error.
Sure. For purposes of certiorari, though, would you agree that it has to be an illegal sentence, that it can't be just simply an error that would otherwise be classified as an appealable error?
I am not sure if fundamentally illegal for purposes of certiorari means the same thing as a sort of void judgment. And that's why I didn't put this in my brief, but I think we would rely also on the palpable abuse of discretion, which and the basis of our claim here is not that Judge Green made a confusion of fact or improperly weighed factors or somehow was improper in his discretionary decisions. We're saying that he was legally wrong. He was required to do one of two things: either leave the sentence as it was, or impose resentencing pursuant to the new version of the law. And he was very clear on the record. He was doing something else. He was splitting the difference by mixing and matching. And so I think that falls under the palpable abuse of discretion in the sense it's a clear error of law. There is no legal authority for the approach that he took. And so if we don't have a right under Rule 3, we get there palpable abuse of discretion and perhaps fundamental illegality under the common law writ. Having said that, I'm not sure that there's a whole lot else to say in terms of what the error is. I think we have covered that. We are not making, I think we could have perhaps made arguments that Judge Green misunderstood or misapplied the issues about the park zone. That's not the claim we're making. We're making that the outcome that he reached, which is to impose a range 2 sentence of 15 years at 35%, and to impose the range 1 mandatory minimum 100% service number of 8 years, is one that no statute authorizes.
You mentioned the park zone, though. I mean, can't you see a little method to the madness here? He was basically imposing a park zone sentence, was he not? I mean, I don't know if he came out and said that, but he was given, at a range 1, albeit, but he was given 8 years minimum with 100% service, which would be a park zone sentence on a range 1, and he stacked the second half of it as range 2, as I understand. But doesn't it kind of get to the point the state was making in their brief? The defendant did get a break here. We're coming off of 15 at 100, which as originally charged, as I understand it, would have been 25 at 100 at range 2. And now you have 8 and 100. And wouldn't it be possible, if this case were to be remanded, that the trial court could just say, well, I was comfortable with 8 at 100, but I'm not comfortable with 12 at 35. I'm just going to deny the motion. It's discretionary. Wouldn't that be within his discretion to do that and leave the 15-year sentence in place at 100%?
That would be a legal outcome. I mean, we would have to hear his explanation and whether that had to do with
It would at
his
least be on the table.
unhappiness for us having appealed or whatever. There are reasons to be improper to reach that outcome.
Sure.
But our argument is not that Mr. Watson absolutely was entitled to a better outcome and this court should impose that better outcome. Our argument is that Judge Green had two options to choose between, and he chose a third option, and this court needs to send it back to him to choose one of those two options.
And if he chooses the option of, I'm just not going to change anything, I'm going to leave the original sentence alone, then you don't have an appeal on that.
Under Bobo, we would not have an appeal under that, under Rule 3.
Okay.
I could certainly be back with a more expansive argument at that time, but I hope we don't reach that situation. But I'm
Thank you.
reserve the rest of my time for rebuttal.
Sure, thank you. State.
Good morning, Your Honors. May it please the Court. Garrett Ward here today on behalf of the state. Your Honors, I'll start where I think sort of this appeal revolves, and that is around this court's jurisdiction, around appeal as of right. And if I may, I think the consideration of this question sort of needs to happen with the act and the Drug-Free Zone Act itself in mind. So a little bit of consideration as to how the defendant's ability to petition for resentencing under the Drug-Free Zone Act came about, I think is important, because it really colors everything that happened below. So when the defendant was initially sentenced in, I believe it was 2010, he would have to serve, based on his offense occurring within 1,000 feet of a school, he'd have to serve 100% of the mandatory minimum. Judge Hickson, as you noted, he was charged as a Range 2 offender. I don't believe there's any real dispute in the record that he had the requisite criminal history, 5 felonies, and some number of misdemeanors to qualify as that. So back in 2010, the defendant was prior to any plea agreements, looking at probably a 25-year mandatory minimum sentence. The state, pursuant to a plea agreement, allowed him to plea down a range for the explicit purpose of lowering that mandatory minimum. So that's where the defendant's case starts. About 10 years later, in 2020, the General Assembly amends the Drug-Free Zone Act, makes a number of changes, altering the requirement to serve 100% of the minimum sentence for range, changing the sort of the zone boundary itself from 1,000 to 500 feet. That occurs in 2020. Those 2020 amendments were not written retroactively. Then in 2022, the General Assembly, purely in an act of largesse, creates this, I don't want to say sort of wholly unique mechanism in Tennessee law, but at least a pretty unusual one of allowing a defendant to seek, years and years and years after judgments become final, after the appellate process is concluded, to seek resentencing. And what the Act, this is subsection H of the Act in the 2022 amendments, what the Act charges trial courts to do is to start with the interests of justice, to consider sort of all of the facts and circumstances of the case, and then, if they conclude that the interests of justice are in favor of resentencing, to go from there. What the Act itself does not do, as this court recognized in both Billingsley and in Bobo, along with a handful of orders on this same issue, what the Act does not do is provide for an appeal as of right. Bobo and Billingsley both arose in a situation where the trial court, outrightly found, look, the interests of justice are not at all in favor of resentencing. And two panels of this court, composed of each panel was composed of 3 different judges, so 6 different judges on this court have sort of concluded that those defendants in that situation have no right of appeal under the statute or under Rule 3. The defendant's argument, principally at its core, is that although he has received some benefit from the Act, he has received some resentencing here, some boon or benefit from the trial court, that he should be able to essentially petition this court seeking more of a benefit, while these defendants who were outrightly denied the largesse, outrightly denied the largesse provided for by the General Assembly based on.
Isn't it a little
Whether he should, I'm sorry,
Go,
Judge.
please.
Whether he should or shouldn't, does Rule 3 grant him the right to do that?
Your Honor, I don't believe the language of Rule 3 does provide for a right of appeal here. Rule 3 is provides for a right of appeal in pretty limited circumstances.
Let me ask you about this language. On a plea of not guilty, which is where we're at here,
Certainly.
if the defendant seeks review of the sentence and there was no plea agreement concerning the sentence, which now is in the unique posture that we're in, it would seem, and here's a separate ground, or if the issues presented for review were not waived as a matter of law by the plea of guilty, and if such issues are apparent from the record of proceedings already had. Does it not seem like there are actually two separate grounds for Rule 3 appeal in this instance?
And Your Honor, I understand defendant's argument, and I'm, to some degree sympathetic for it, but I don't ultimately, at the end of the day, feel like Rule 3 does contemplate a right of appeal in this specific circumstance.
That's good. Explain it to me now.
I'd be happy to, Your Honor.
If you could, and kind of along this line, if you could help me understand also how we would possibly wind up in a situation where a resentencing is occurring, whether it's to the benefit of the defendant or not is really beside the case, where a resentencing occurs upon allegation of the defendant is a fundamental illegality, and we would interpret Rule 3 arising from a new judgment as saying you're just stuck with it. You can't challenge the illegality on direct appeal. You've got to go through a 36.1 motion, writ of certiorari maybe. Help me understand why Rule 3 doesn't cover a situation where you have a brand new judgment and a claim of error in the resentencing.
So I'll address that in sort of two separate points on that, Your Honor. I think first, I'm not certain from defendant's argument whether or not he is, at times it seems he's alleging there is a fundamental illegality, and at times seems to rather steadfastly back off of the argument there's a fundamental illegality.
Well, let me ask you this, because I've not really seen anything quite crafted like this. We talk about hybrid sentences, and we've all seen them. At one point, they were, really frowned upon, but then apparently, if everybody agrees, everything, as long as it's within the range of punishment, it's okay. In this case, you have one sentence with two different release classifications in the sentence. Have you ever seen anything like that?
Aside from sort of instances where parties explicitly agree to that, Your Honor, I can't say that I.
But you would never see a sentence, you would never see, and I'm not sure this is the case here, but you would never see a single 15-year sentence with different release eligibilities applying over the course of the term. There's no statute that authorizes that.
Not that I'm aware of, Your Honor. I believe that in certain circumstances, parties could agree to these sort of hybrid sentences.
General, is there any example where in the context of, like I said, I'm not sure that this is exactly what's going on here, but in the context of one, let's say 15-year term, parties could agree to serve the first 8 years at 100% and the remainder at 35? There's no case that holds that.
Not a case, Your Honor, but to some extent that is how the Drug-Free Zone Act itself is structured. What both the unamended version and the amended version provide is, service at 100% of the mandatory minimum, with the explicit idea in both versions of the act that the remainder can be served at a different percentage. Sure. So okay. I do think that the Drug-Free Zone Act here does contemplate, on reflection, does contemplate there being a difference in service percentage, the language of the act.
Then the response to that is, I took it from the brief, if that's the answer. The response I took from it is, and Judge Hickson pointed this out a minute ago, essentially what the trial court did was to impose the park zone enhancement, but the park zone enhancement was not alleged in the indictment. Doesn't it have to be alleged in the indictment before the trial court would have authority to sentence pursuant to that?
And Your Honor, I understand it was not charged in the indictment. This case presents with a very unique situation in that 12, 13 years ago, there was a very lean indictment drafted with the sort of explicit idea that there would be a quick turnaround on a guilty plea, and there's simply no way for, when this charging decision in 2010 was made, there's no way for the state at that time to foresee any later changes in the law. And I don't know that this court necessarily wants to incentivize a prosecutor charging off every possible theory that he could seek in any case, even if he thinks that is not what justice requires in a case, on the idea that sometime a decade later it may arise that it was prudent to do so based on a subsequent change in the law.
I don't think that's what I'm suggesting. I certainly would never want to incentivize that. Certainly. I think what I was suggesting, from what I understood the appellant's argument to be, was that even if you could, under the Drug-Free Zones Act, have a mixing and matching of release eligibility percentages over the course of a term, it couldn't happen here regardless, because it wasn't. The proper enhancement wasn't included in the indictment. Irrespective of foreseeability, it's just not there. And so you don't have the authority, would not have the authority now under even the Drug-Free Zones Act, in addition to not having the authority elsewhere.
So on that, Your Honor, when what the Act says is when the trial court makes the ultimate decision to engage in resentencing, based on its finding that the interest of justice is in favor of, and that's principally what the trial court first determined here, is that the interest of justice were in favor of some resentencing. The trial court is when it makes that decision, supposed to consider all of the factors, all of the circumstances of this case. And I believe that in this case, one of those facts and circumstances, when we're in this sort of odd interest of justice driven resentencing scheme, one of those facts and circumstances that really the trial court needs to be able to consider is sort of this wider fact situation than just what was strictly in the indictment.
But the problem, the thing about that though is, he pled guilty to a specific charge. It was a specific charging instrument in 2010.
Yes, Your Honor.
And if I understand your argument, in your brief, was that because there's been this change, it expands the universe of what the judge then can consider. But can you do that with an indictment? I mean, you have charges, and again, if something's been, you get an amendment to the indictment later, or amendment to the statute later that adds other things, can you go back and just consider those new things for resentencing that were never contemplated at the time of charging or plea?
Well, Your Honor, I don't know that I'd go so far as to say never contemplated. Principally, this indictment charged the defendant with possession with intent to sell and possession with intent to deliver in a drug-free zone. To some extent, yes, the initial indictment does specify a type of zone, but it's not as if we're in an entirely sort of new world of new universe of legal theories here. We're still principally talking about, even if the court is now.
Okay, let me ask you this. If he had gone to trial in 2010 and the indictment was written the way it was, and the state proves, it wasn't a school zone, it was a different zone, would that be? There might be a
variance issue at that stage, Your Honor. Yeah. I'm not going to stand before the court and sort of suggest that there would be no potential variance problem.
It's an Apprendi issue, isn't it?
Pardon me, Your Honor?
Isn't it an Apprendi issue?
Yeah.
I mean, so the indictment would have to allege it, and it would have to be proven to a jury, right, to have the enhancement over the minimum?
Yes, Your Honor.
So, okay. I guess what I'm trying to think about is that even if the trial court has to consider all the facts and circumstances now, because I think you're laying out pretty well the argument, but at the same time, the trial court surely cannot consider a fact that it wouldn't be allowed to consider, but for Apprendi.
Your Honor, to some extent, it's a little difficult to analyze Apprendi here because we do arise in the context of a guilty plea as opposed to a trial. There are some sort of idiosyncrasies of Apprendi and its progeny that are difficult to grasp onto a guilty plea case.
But I think we're still back to the point, though, is this idea that this change, even though it's benefiting the defendant, and it clearly is benefiting the defendant, which is a whole other issue, but the idea that it opens up the charging universe to factors that weren't in play in 2010. And, that's a pretty big, that's a pretty big ask when you start thinking about what did the defendant agree to, what was the, originally, and then you come down here, even if it's to his benefit, the court's adding things that were outside the indictment, and it's hard to kind of, how can you, I know you're talking about the intent and, to make this work, the court should be considering these things, but isn't the court still bound by what the charge was, the charging instrument?
That may end up being the case, Your Honor. I think in analyzing this question in this specific case, the Act does specifically tell trial courts to consider these facts and circumstances. Perhaps the sort of principal issue with what the trial court did here is that it considered, to the extent this was a problem, is that it considered these facts and circumstances sort of on both sides of the equation, both in determining whether the interest of justice demanded resentencing in the first place, and then it carried that over. The likely outcome I see is that if this court were to determine that the trial court should not have continued to consider these facts and circumstances, is that we will wind up in a situation where the trial court is presented with this, this statute that is very clearly written with the intent to, grant some grant some sort of equitable remedy almost to a defendant, and then we present a trial court with this very stark all or nothing approach, that we will sort of wind up in this situation where trial courts are remiss to sort of utilize the 2022 amendments to the Act because they're sort of presented with this all or nothing proposition. And I certainly understand opposing counsel's argument. I understand this court's concerns, but I think it's important in analyzing this issue to not lose sight of what this Act is trying to do, to not lose sight of what the General Assembly wanted trial courts to do in these Drug-Free Zone Act cases. Principally, the General Assembly was recognizing that they have made this policy determination that the prior version of the Act was perhaps a little too harsh on defendants, and then wanted to provide trial courts with a tool to grant defendants some relief. And that's
All of that would work when the defendant consents to it, correct? So you could have a situation where the defendant consents to, sure, I'm happy to have the trial court consider a fact it couldn't consider because the indictment doesn't allege it, but I consent to that happening. Here you have a defendant who's not consenting.
I don't know that I would say there's really any firm position in the record below about whether or not the trial court can, consider the fact that this occurred near a park. There's some discussion of it. I think the parties disagree on what that means. But I think it's fairly clear from the Act that at least on the front end, the court can, and when I say front end, I mean this initial interest of justice determination, that is very explicitly a fact that it can consider. And perhaps on rebuttal, opposing counsel will disabuse me of that notion. I didn't understand him to be saying that was something that the trial court just point blank could not consider in any manner. Perhaps as I understood his argument, it was more that the trial court could not consider it perhaps throughout the entirety of this process. And I'm sympathetic to that argument, and I understand his position. I just worry that proceeding with such sort of a stark delineated road in this case will end up frustrating the purpose of the General Assembly in passing this Act. And I do understand that it, at times the language used in passing a statute in and of itself can wind up frustrating the intent of the General Assembly and the statutes it passes. And if that's what comes to pass, that may be. I just want to urge the court to consider what the General Assembly is trying to do here in rendering its decision. So if this court does not have further questions, I would ask that the appeal be dismissed, or that the trial court's imposed sentence be affirmed. Thank you, Your Honor.
Thank you.
Thank you.
Thank you, Joe.
I think Mr. Ward's actually done a pretty good job of setting out my position, but I'll try to do it again. In that there is, as he says, there's two stages. There is the stage of, are we going to have a resentencing? And there are things that can be considered, and then the judge makes a decision. And if the judge makes the decision, then there is a resentencing pursuant to the law as it now stands. So there's not some resentencing, there's not partial relief, there's not a equitable determination. I mean, Judge Green here obviously was trying to be fair and equitable and come up with a solution that seemed right to him. Our position is that the legislature did not give him that option. It gave him the option, if he was going to, in the interest of justice, decide that relief should be given to Mr. Watson, that he had to impose a sentence under the new law. And the sentence imposed under the new law, based on this record, would have been a 12 to 20 year range 2 sentence at 35%. I think the park zone, in a way, is kind of a red herring here, because the state tried to prove up a park zone and it failed. They put on their officer to establish, he did probably establish the distance to the park zone, but sort of, I think perhaps as a surprise to the prosecutor, he was asked, you remember, kids playing in the park, right? And he's like, I don't remember ever seeing a kid in that park. So under the current law, there's a rebuttable presumption that the mandatory minimum will not apply in the absence of indications that vulnerable people are exposed to the dangers of the drugs. And here, the state tried and signally failed to prove that. So it's I'm not asking, I guess, the court to rule on that directly, but it is our position that what Judge Green was required to do, having decided to, in the interest of justice, to alter Mr. Watson's sentence, was to re-sentence under the law as it now stands, and that re-sentencing on these facts would have resulted in the 12 to 20 at 35% sentence. So there would not have been a mandatory minimum of any kind. If there are no other questions, we would ask that this case be remanded for further proceedings. Thank you.
Anything else? Thank you all.
Thank you, counsel. Thank you.
Madam Clerk, are there any other matters before the court?
No, sir, Your Honor.
All right, well, this court will stand adjourned.
All rise.